at Diddy's memorandum of law in opposition to the motion to quash his request for all of Cassandra Ventura's information. Case number 24-CR-542, United States of America v. Sean Combs. Redacted seeks to shield important exculpatory information in her possession, and the government joins in that request. In particular, she and the government seek to conceal copies of her draft memoirs and other writings that memorialize a version of events that is markedly different from what she has told the government and will testify to at trial. Next part, redacted. These relevant and admissible materials are crucial to the defense. They are precisely the types of documents that criminal defendants are entitled to subpoena from third parties. Moreover, depriving Mr. Combs of such material would interfere with the Sixth Amendment right to present a meaningful defense and Fifth Amendment due process rights. For these reasons, the court should deny the motions and order redacted to comply with the subpoena. Background, redacted. 2 sections redacted. On March 18, 2025, Mr. Combs made an ex parte application for a Rule 17c subpoena to redacted, seeking 2 categories of documents. 1. All draft memoirs, autobiographies, narratives, diaries, journals, or notes, redacted, and any communications about her plans to publish or threaten to publish such a document. And 2. All bank statements, redacted. The subpoena. Court authorized the subpoena on March 19, 2025, and defense counsel provided a copy to redacted's counsel who accepted service. Next section, redacted. Argument. The subpoena satisfies Rule 17c. A. Rule 17c provides proper standard for compliance with the subpoena. At the outset, redacted and the government argue that this court should apply the standard articulated in United States v. Nixon, but there is no sound basis to do so. Federal Rule of Criminal Procedure 17 governs the issuance of subpoenas by the parties to a criminal proceeding. While the court has authority to quash or modify a subpoena, it may do so only if compliance would be unreasonable or oppressive. Fedar Crim P 17C2. And the government argues that material sought pursuant to Rule 17c must be relevant, admissible, and specific. This 3-part standard, which derives from the Supreme Court's decision in Nixon, 418 U.S. 683, does not apply here. In Nixon, the grand jury investigating Watergate returned an indictment that named then-President Nixon as an unindicted co-conspirator. The government then subpoenaed the president, a non-party, who moved to quash. The Supreme Court affirmed the denial of the president's motion, finding that the government subpoena cleared 3 hurdles applied by lower courts to criminal subpoenas. 1. Relevancy. 2. Admissibility. And 3. Specificity. ID at 700. The Supreme Court in Nixon adopted this standard from United States Iozoa 13 FRD 335 SDNY 1952, a case in which defendant had subpoenaed the government, CID at 337 and 38. Iozia required the defendant to satisfy a heightened standard because by serving a Rule 17 subpoena on the government, he was potentially circumventing Rule 16's limits on discovery from the government, CID at 338. Nixon involved in the more unusual situation present here, where the subpoena, rather than being directed to the government by defendant or vice versa, issues to a third party, 418 U.S. at 699. As a result, the government in Nixon argued that the heightened standard in Iozia does not apply its full vigor when the subpoena is issued to third parties rather than the government prosecutors. The Supreme Court neither accepted nor rejected this argument, instead declining to decide whether a lower standard exists because the subpoena satisfied the more stringent standard. In the decades since Nixon, courts have split over whether subpoenas to third parties are subject to that standard. The most thorough and persuasive analysis appears in U.S. v. Tucker, 249 FRD SDNY 2008, where the court concluded that Nixon's standard should not blindly be applied to all subpoenas, CID at 60 through 67. Unlike the government, a criminal defendant has a Sixth Amendment right to a compulsory process and to confront witnesses. The right to cross-examination has been held to be an essential purpose of the Confrontation Clause, and this right is meaningless if a defendant is denied the reasonable opportunity to obtain material evidence that could be crucial to that cross-examination. ID at 67. As the Supreme Court observed in rejecting the president's privilege objection to the subpoena in Nixon, the right to the production of all evidence at a criminal trial has constitutional dimensions. The Sixth Amendment explicitly confers upon every defendant in a criminal trial the right to be confronted with the witnesses against him and to have a compulsory process for obtaining witnesses in his favor. Moreover, the Fifth Amendment also guarantees that no person shall be deprived of liberty without due process of law. It is the manifest duty of the courts to vindicate those guarantees, and to accomplish that, it is essential that all relevant and admissible evidence be produced. The plain text of Rule 17 is not as restrictive as the Nixon standard, and applying Nixon to all third-party subpoenas would allow the government to prevent defendants from obtaining relevant material by choosing not to obtain it for itself, and thereby avoiding any disclosure obligations, a perverse result that cannot be intended by the federal rules of criminal procedure. Tucker 249 at 65. In Tucker, the court expressly found that the Nixon standard is inappropriate where the production is requested by A, a criminal defendant, B, on the eve of trial, C, from a non-party, D, where the defendant has an articulable suspicion that the documents may be material to his defense. Consequently, a defendant issuing a subpoena to a non-party need only show that the request is 1, reasonable, construed as material to the defense, and 2, not unduly oppressive for the producing party to respond. See Nashimi 91 F.SUPP 2D at 561 through 63. Applying that standard, the court in Tucker approved a subpoena seeking recordings of phone calls made by cooperating witnesses for the purpose of impeaching those witnesses at trial. Tucker's reasoning is compelling, as several courts in this circuit have recognized. In U.S. v. Roger Rotnam 753 F.SUPP 2D 317 SDNY 2011, the court observed that according to the government's misreading of Nixon, a defendant in breach of contract case can call on the power of the courts to compel third parties to produce any documents reasonably calculated to lead to the discovery of admissible evidence. While Tucker noted that the subpoena in that case was issued on the eve of trial, ID at 66, the rationale for refusing to extend Nixon to defense subpoenas to third parties apply regardless of when the subpoena is issued. Indeed, the Tucker court recognized that in Nashimi, it had suggested that this test was appropriate for all defense subpoenas directed to non-parties, ID at 66, N.51, citing United States v. Nashimi 91 F.SUPP 2D 552 SDNY 2000. But the defendant on trial for his life or liberty does not even have the right to obtain documents material to his defense from the same third parties. ID at 321, quoting Fedar Civ P 26 B1. The court in Roger Rotnam had no occasion to apply Tucker, as the subpoena at issue satisfied Nixon. In United States v. Goldstein, number 21, CR 550, EDNY, May 25, 2023, however, the court followed Tucker to grant in part and deny in part the government's motion to quash several 17C subpoenas, noting in particular that other lower courts that have instinctively followed Nixon did so despite the fact that Nixon did not determine the propriety of Rule 17C subpoena issued by a defendant to a third party, idea 2. United States v. Weigand, 520, SDNY 2021. The court noted that Tucker is more consistent with modern principles of liberal discovery than Nixon because permitting issuance of reasonable third-party subpoenas to take discovery appropriately aligns criminal discovery more closely with modern principles of liberal discovery and better balances the discovery powers of government and defense. ID at 613, also see United States v. Akhavan, number 20 CR 188 2 JSR 2021 WL 1251893 at 1 SDNY April 2nd, 2021. Likewise, in United States v. Solomon, 66 CR 236A 2009 WDNY May 29, 2009. The court applied Tucker in granting the defendant's motion for pretrial subpoenas, holding that even if the documents sought were potentially voluminous, there was a reasonable connection between his requests and his defense, and the subpoenas could further be tailored if necessary to mitigate the burden of responding. Like the court in Tucker, this court should apply the standards set forth in the plain text of Rule 17C. There's no binding precedent requiring the court to extend Nixon to this case. The district court decision, which have rejected Tucker, are not binding on this court. See Carmetta v. Green 563, 2011, which remains free to disagree with them, Hawkins, Steingut, Second Circuit, 1987. In fact, every federal court in the land is obliged to apply federal law interpreted as best that court can in light of the precedents that bind it. Refco Incorporated, 628 F.SUPP SDNY 2008. If a federal court simply accepts the interpretation of another court without independently addressing the merits, it's not doing its job. Nixon should not so readily be divorced from the concerns that produced it, and is vitally important not to let its frequent repetition lead to mindless application in circumstances where it was never intended to apply. Roger Rotnam, 753, F.SUPP 2D at 321, N.1, quoting United States v. Stein. SDNY 2007. Indeed, the Advisory Committee on Criminal Rules has been studying Rule 17 and is in the process of recommending a new amendment that would clarify the showing necessary for a Rule 17 subpoena and explicitly relax Nixon admissibility requirement. Just recently, on March 28, 2025, the Rule 17 subcommittee released its new discussion draft reflecting the committee's intention to change the standard to either likely to be admissible or likely to lead to evidence that will be admissible. The committee was persuaded that the courts had applied the admissibility requirement in Nixon's interpretation of prior text inconsistently, and sometimes too rigidly, and the revised text is intended to provide an adequate and consistent opportunity for both the prosecution and the defense to obtain the evidence they need from third parties. The cases relied upon by the government and redacted reflect exactly the sort of rigid interpretation of Nixon that the committee seeks to correct. All right, we're going to wrap up right here, and in the next episode, we're going to pick up where we left off. All of the information that goes with this episode can be found in the description box. What's up, everyone, and welcome to another episode of the Diddy Diaries. In this episode, we're picking up where we left off with Diddy's motion in response to Cassie trying to quash the request for documents. B. The subpoena is neither unreasonable nor oppressive. The subpoena easily satisfies Rule 17 standard. First, the subpoenas are plainly not unreasonable, as they seek evidence material to the defense. Tucker 249 FRD at 66. Redacted's draft memoirs will show an account of Redacted that is different from the story she's provided to the government and undermines her allegations Redacted. Indeed, the responsive material that Redacted recently provided to the government includes highly exculpatory statements, redacted, redacted, and redacted. It is core impeachment material and integral to the defense. See Goldstein, 2023 WL 366-2971 at 4. Denying in part the motion to quash for because impeachment material were integral to the defense, and noting that the right to confront one's accusers is meaningless if a defendant is denied the reasonable opportunity to obtain material evidence that could be crucial to that cross-examination. Quoting Tucker, quoting Tucker, 249 FRD at 67. Next part, redacted. There is no reason to treat the relevance of Redacted's bank records any differently, and the enforcement of a Rule 17c subpoena can serve to correct the government's selective investigation. The subpoena is also in no way oppressive. The subpoena seeks two categories of documents, both limited in scope and time, far from sweeping as characterized by Redacted. See Redacted's motion to quash, Redacted motion, dated April 2nd, 2025 at 3. It is a targeted request aimed at a specific set of documents that are exclusively within the Redacted's possession. Redacted makes no argument with respect to undue burden or expense that would warrant an inference that compliance with the subpoena would be oppressive. Moreover, Redacted claims that the subpoena is burdensome, should be measured against her full participation in the government's investigation. To date, redacted has sat for at least 6 interviews with the government, provided access to multiple electronic devices, and searched for records that selectively corroborate the government's theory that she now claims to be burdened by a simple request for limited material is transparently an attempt to shield exculpatory information from the defense. 2. In the alternative, the subpoenas satisfy the Nixon standard. Even under the more restrictive Nixon standard, the motion to quash is meritless because the subpoena easily states that the 3 hurdles of 1. Relevancy, 2. Admissibility, and 3. Specificity. Nixon 418, U.S. at 700. In United States v. Barnes, the court declined to decide whether Tucker or Nixon applied to a defense subpoena to a third party because the defendant showing failed to satisfy Tucker, 560 F. Appendix 36, 40 and 1, Second Circuit, 2014, while the Second Circuit recited the Nixon standard in the United States v. Ulbricht, 858 F. 3D 71, Second Circuit, 2017. The defendant there did not advocate for or even cite the Tucker standard, and the court's reference to Nixon was dicta, since it did not actually rely on the Nixon standard. Rather, it found that the evidence sought was irrelevant and could compromise a grand jury's investigation, and that its exclusion was harmless. CID at 109 and 10. In United States v. Bergstein, 788, F. Appendix 742, Second Circuit, 2019, the Second Circuit refused to reject Tucker's more liberal approach, leaving the question open. Weigand 520 F. SUPP 3D at 612, summarizing Bergstein. In United States v. Scalos, the court found no abuse of discretion in the district court's decision to quash the subpoenas, also without ruling on the appropriate standard under Nixon or Tucker. 88 F. 3D 645, 661 Second Circuit, 2021. A. The subpoena seeks relevant and admissible documents. Although Nixon is a more stringent standard than Tucker, Nixon's relevant standard is often overstated. Evidence is relevant if it tends to make the fact more or less probable, and the fact is of consequence in determining the action. Fedar Evidence 401. All relevant evidence is presumptively admissible. See Fedar Evidence 402. Combs need only show that he sought after evidence could potentially serve a valid purpose. See Nixon 418 U.S. at 701. Subpoena was proper where there was valid potential evidentiary uses for the requested material. ID at 699 and 11. Advisory Committee Draft Rule 17 for the purpose of enabling the party to see whether he can use the evidence or whether he wants to use it. Irving 600 F.2D 1027, 1034 Second Circuit, 1979. Subpoena for union sign-up cards was permissible because if the cards are in fact forged or otherwise fraudulent, they may provide the defendants with a basis for asserting an entrapment defense. U.S. v. Yudong Zhu, 13 CRWL, 2 and 3 SDNY October 14, 2014. Subpoena may properly seek documents that are potentially admissible. U.S. v. Carollo, 2012, SDNY April 9th. Subpoena is proper if a document is arguably relevant and admissible. United States v. Weisberg, 08 CR 347 NGG RML 2011 WL 132 7689 at 7 EDNY April 5, 2011. Upholding subpoena of records likely to contain helpful documents. Roger Rotnam, 753 F.SUPP 2D at 321 N1 323. Potential evidentiary uses satisfy the admissibility requirement. Nachemi, 91 F.SUPP 2D at 564. Subpoenas may seek documents likely to be admissible at trial. United States v. Orena, EDNY 1995. Approving subpoena of records that were at least potentially admissible and that might also form the basis for eliciting certain testimony at trial. The government's main argument is that the subpoenas seek impeachment material. The evidence sought is admissible for several purposes other than impeachment, and regardless, the subpoenas would be valid even if they only sought impeachment material. First, redacted evidence that contradicts those claims is not just impeachment, it is affirmatively exculpatory. Thus, evidence that redacted, among other exculpatory statements, will be crucial in cross-examining redacted about her claims and admissible as prior inconsistent statements. Redacted. Evidence of redacted's motive to lie is plainly admissible, and courts regularly permit Rule 17 subpoenas seeking this type of evidence. Martin Marietta Corp. 856 F.2D 619-622 4th Circuit 1988. Defendant could subpoena evidence that his employer hung him out to dry while protecting its own interest. Yu Dong Zhou, 2014 WL at 5 denying motion to quash subpoena seeking evidence of witness bias. Carollo, 2012 1195-194 at 1 through 3. Subpoena could seek evidence that cooperator transferred money to Swiss banks before pleading guilty, which suggested a motive to cooperate with the government in order to protect assets or guard against additional charges for other crimes. Orena 883 F.SUPP at 869. Subpoena could seek evidence that illuminates the factors that led an individual to become a prosecution witness and the benefits he obtained by doing so. The argument that impeachment material should not be sought in advance of trial makes little sense here, where it's obvious that redacted. Indeed, that is the core of the government's case. The subjects of her testimony are not speculative. See redacted motion at 3. Under these circumstances, the defendant need not wait until trial to seek impeachment material. CEG U.S. v. LaRouche, Campaign 841 F.2D 1176-1180, 1st Circuit, 1988. Permitting pretrial subpoena of impeachment evidence where a putative key witness, whose general testimony is already known, is scheduled to testify. See also U.S. v. King, 194 FRD 569, 574 and 75, ED Virginia, 2000. B. The subpoena is sufficiently specific and not a fishing expedition. There's no basis to quash the subpoena on specificity grounds either. A defendant need not have prior knowledge of specific documents to meet the specificity requirement of Rule 17, Weisberg 2011 at 7. According to Roger Rotnam 753, F.SUPP 2D at 321 and 1, requiring the defendant to specify precisely the documents he wants without knowing what they are would render Rule 17 a nullity. Rather, if the defendant identifies a group of records likely to contain helpful documents, his request is sufficiently specific and he cannot be said to be engaging in a fishing expedition. Weisberg 2011 at 7. This is especially so if there is no indication that the production of the documents identified would require the subpoena recipient to allocate significant resources in order to comply. Yu Dong Zhu, 2014 at 6. See also U.S. v. McClure, 2010. Specificity requirements focuses on undue cost, burden, or delay associated with excessively broad requests. Finally, these requests are plainly not a fishing expedition, as redacted characterizes them. Redacted at 3. The subpoena delineates two categories, each aimed at discrete, limited timeframes, pertaining to subject matter that is directly at issue in this trial. As well, within the redacted's knowledge, and notwithstanding redacted's relevant selective production, the requested documents have not been produced to the government. And that's the only other version of the narrative. Indeed, her attempts to quash the subpoena with respect to the remaining responsive documents suggest that further, more exculpatory material exists. And contrary to redacted's suggestion, the request for bank statements over a limited period of during and leading up to her motive to lie does not target nebulous financial wrongdoing, rather redacted. Conclusion. For the foregoing reasons, the motion to quash should be denied. This was signed by Mark Agnafilo, and it was dated April 7th, 2025. All of the information that goes with this episode can be found in the description box.